Hi, this is Ed Sullivan and Mark Oberti with Oberti Sullivan Law Firm. Mark, as you know, on June 25th, 2012, the U.S. Supreme Court granted certiorari, meaning they're going to hear argument on the case of Genesis Healthcare versus Symczyk. This is a really important case for anyone who does FLSA litigation, whether they be plaintiff, defendant, or both. Why don't you talk a little bit about the case and let's have a dialogue about it.
Yeah, sure, Ed. And of course, what happens in your typical Fair Labor Standards Act collective action case is one or two, kind of handful of named plaintiffs file the lawsuit, and then later on they file a motion for conditional certification seeking the judge's permission to send notice to all the other similarly situated class members. And before they do that, though, sometimes the defendant makes an offer of judgment to the named plaintiffs, and then assuming that offer of judgment undisputedly covers all their damages, well, then the question is, and the defendant which would argue, well, there's no case or controversy anymore and the court lacks jurisdiction, and so at that point it's moot, and the plaintiffs can't even send out a conditional certification notice because there isn't any case or controversy.
So what did, yeah, and so
kind of a strategic tactic, and how has it worked so far, Ed?
Well, I mean, it's really an interesting phenomenon. You have two circuits. You have the Fifth Circuit, which is where we are at, which is covers the areas of Texas, Louisiana, and Mississippi. You also have the Third Circuit, which is out in the Northeast, but not the far Northeast. But in any event, what they said is, look, if defendants are using this offer of judgment rule to pick off a potential collective action certification, that would be inappropriate, and that as long as the plaintiff moves without undue delay in asking for a collective action, even if an offer of judgment went to the individual plaintiff, they can move forward with that lawsuit. Now, this puts in a conflict with the 11th Circuit from a decision it made, and so that's why the Supreme Court has taken the case. But from an employer perspective, offers of judgment are one of the very few arrows in the quiver of a defense lawyer, Mark.
Well, what do you think? We don't know what the Supreme Court's going to do. The way I look at it is the case kind of presents a conflict between, on the one hand, you have the principles of Rule 216B and Supreme Court cases that kind of emphasize that collective action is encouraged so that all the victims of this allegedly similar policy can get a remedy at the same time. And so that's why I think that's one of the reasons the Fifth Circuit in this Third Circuit case said, listen, we're not going to allow defendants to just pick off the named plaintiffs and thereby subvert and defeat the collective action, because that's contrary to the whole purpose of Rule 216B as articulated by the Supreme Court. On the other hand, you got the plain language of Rule 68 and offer of judgment, and so defendants say, hey, it may not be fair, who cares? This is the law. Well, and so how's it going to play out at the Supreme Court? What do you think?
Who knows? But here's another point, which is, I mean, Article 3 doesn't delineate. Article 3 says there must be an actual case for controversy, and the case must be right. I mean, some of the justices, I think, will do it just like the text of the Constitution, at the text of Rule 68, the text of Rule 216B, like you said. But on the other hand, the Fifth Circuit is pretty known to be fairly employer-friendly, not universally, and there's obviously some cases out there, but even the judges of the Fifth Circuit would probably admit that. And for them to have a pro-plaintiff ruling under this type of jurisprudence suggests that the Supreme Court would probably affirm the decision in the Third Circuit. But, one never knows. I'm not a legal scholar like any of the 9 of them, but I think it'll be a close case.
I think if they affirm it, pretty much the general practice of FLSA collective actions goes on as it has been, at least in our jurisdiction. But if, on the other hand, they reverse it and say that this is a lawful tactic, although, I think lawyers oftentimes too often claim that the sky is falling based on one opinion. But I think in this case, if they reverse it, wouldn't that just have a dramatic effect on the plaintiff's bar in collective action cases?
Well, yeah, and it would change the litigation. Right now, FLSA, or Fair Labor Standards Act litigation, swamps the federal courts for lots of reasons. There's lots of violations, and the law is pretty technical. If you allow defendants to make offers of judgment immediately and you can moot out a collective action, well, a lot of employers are going to send one first thing, regardless of the merits of whether they did it or not. Who's going to try and cut out the entire case? It'd be an interesting legal tactic. There is a potential for middle ground here, which is on this issue of so long as the plaintiff acts without undue delay. In the Symczyk versus Genesis Healthcare case, Of course, there never was a motion for collective action filed. The motion to dismiss was filed before that. So you may get to a point where the Supreme Court says as long as a motion is filed concurrently with a complaint or something like that, it would be okay.
I see.
So there's a
kind of a split the baby option.
There's a potential, but then you get into a lot of other issues. But hopefully we've teed this off for you just a little bit for all you Rule 68 and FLSA and Supreme Court aficionados, and have a great day.
Keep your eye on it.